Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon, and I am your host. And it's another Saturday afternoon live on BWTV. We're bringing you another edition of The Community and the Law. This afternoon, I'm asking the question, can I switch from skilled worker visa to EUSS pre-settled status? I can hear some people say yes. I can hear some people say no. Maybe you stand in the middle and say maybe. Laura Charles Asma is our guest and resource person. Remember, we're doing this under the auspices of BWF Solicitors, our trusted partners when it comes to the law. So get yourself ready. Let's all get into the program, The Community and the Law.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hello once again, and welcome to another edition of the program, The Community and the Law, brought to you by BWF Solicitors. This afternoon, we're looking at a very interesting question, and it is, can I switch from skilled worker route to EUSS pre-settled status? Why are we asking that? We know in recent times there have been revocations and curtailment of skilled worker visas and the sponsorship. And we are looking at situations where when you're giving some time to find your level, you're able to do so. So the options are being explored. And this afternoon, we're exploring one of them, pre-settled status, when it is that you have had your visa curtailed or you want to vary it one way or the other for one reason or the other. Lawyer Charles Asma, resource person, will be here to help with that. My name is Ulriku Frimpon, and I have the privilege of hosting the program between now and 6 p.m. UK time. We are live on BWF Solicitors social media platforms. We're talking about Facebook and YouTube at BWF Solicitors, and of course also on BWTV at BWTV, both Facebook and YouTube. So those of you who have joined us, let's do some housekeeping and welcome you on board. When you log on, please like the program, pick up the link and share, and also click on the notification button so that whenever we put any content on, you will be notified of that. And then invite other people to come in, because we are here to share knowledge, update ourselves with whatever it is that the laws have put into the community. And then again, we have solutions to your situations and answer to your questions. BWF Solicitors is located on the fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters in North London. You can call them on 0208 493 7340. The number again, 0208 493 7340. Those of you in Ghana, there's an office in Accra, and you can reach that office on 055 589 5959. 055 589 5959 in Accra. And in all emergency situations, you can call 077 127 61884. Those are UK number. So you can send your text, WhatsApp, or even call 077 127 61884. BWF Solicitors are trusted partners when it comes to the law. Hello, lovely family. Tilly Duma is welcoming you to the program, and I want to add my voice to that. Thank you for joining us. Management Senior Minister, Brad, why? The class is going on. Yes, we deem this like a classroom, and when it is that we come on board, we expect people to come in and enjoy the class. Lawyer Charles Asma will be our resource person and teacher this afternoon to tell us what steps we can take if it is that we can switch from skilled worker visas to EUSS pre-settled status. Adesafo welcomes us with a good afternoon, and he says, good afternoon, everyone. Ketrini, you send us a love emoji. We love you back. Thank you very much, Ketrini. God bless you for joining us. I believe you're going to share the page for other people to also join us as well. Nanette Ahine Tilly is calling you. Sarah Pinzo and Tilly is calling you. Gifty Asiedu Koranche. I think these are some of the regular members of the class, and your names are being mentioned here. Kindly share when you join. Admonition from Ade Safo, and I pray you that when it is that you join us, you share. Remember, we are live on Facebook and YouTube at BWF Solicitors and at BWTV. Now, people who have visited BWF Solicitors, remember they work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Now, those who visit us, those who use our services, give us the review. We encourage you to do that. You can do that on our social media platforms, or you go on Google and leave us that feedback. Elizabeth has come in with this one, and she says, I would like to express my heartfelt appreciation to the entire team at BWF Solicitors, especially Ms. Abigail, for the successful outcome of my children's student dependent visa application. Throughout this journey, she says, your support went far beyond legal representation. The professionalism, calmness, encouragement, and the motivation you provided during what was a very stressful period meant so much to me. It made it easier, to say. And she says that every interaction reassured me that my case was in capable hands, and your guidance gave me the confidence to remain hopeful even during challenging moments. Ms. Abigail, thank you for your dedication. Thank you for your kindness. And thank you for your consistent support. Your commitment to my kid's case will never be forgotten. And Elizabeth goes on to say that I'm grateful to the entire BWF Solicitors team for helping make this journey possible for my children. And once again, Elizabeth says, thank you. This is a very interesting story. This is a very pleasant one. This is feedback that we would want you to give. Whatever goes right, we share the glory with you. If there's anything we have to do better, please let us know so we can improve upon our services even the better to serve you the better. You know what I mean. So BWF Solicitors, remember to call us on 0208 493 7340, or you can visit our offices on the fourth floor of the Anna House, 214 to 218. Tottenham High Road, Seven Sisters in North London. In Ghana, those of you there, 055 589 5959. And in all emergency situations, call 0044 7712 761884. Our social media handles, Facebook, YouTube, X, and TikTok at BWF Solicitors. And our website, www.bwfsolicitors.com. We have a lot of resources on our website that will help you. Articles, updating all the situations that come up. Lawyer Bernardo Usu, our senior partner, is always putting up articles and resources to help you do that. So join the BWF Solicitors family and we will work with you together. Let's say thank you to BWF Solicitors. After this, we will come back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Well, thank you very much for sticking around. We're right back into the fray, and we're going to give you some updates uh, that we have received. Earlier in the week, remember, we always put out the nugget. We'll be getting to that. But in the meantime, let's appreciate our senior partner. The week past, we had the celebration of Father's Day, and BWF Solicitors, the family would want me to uh, just give this message to our senior partner and say to him that Uncle Ben, um, we thank you for your exemplary leadership, wisdom, and unwavering dedication. Your commitment to family and service continues to inspire us all. So on Father's Day, we wish you a blessed and joyful Father's Day. We didn't have the opportunity to do that on Sunday in the past week, but we have the opportunity to do that today. And on behalf of the community, the client community, the family out there, everybody wants me to express that wish to you. Happy Father's Day. Thank you. We're celebrating you as a leader, a mentor, and father extraordinaire. Thank you for all you do, and please continue to do that for us. Thank you very much. The update we have, in fact, on Thursday, the 25th of June, 2026, there was an update from the House of Lords and Home Affairs Committee on settlement, citizenship, and integration. So they gave us a report, and this report said that the House of Lords Justice and Home Affairs Committee has recommended that the government should not extend the standard settlement route from 5 years to 10 years and should not apply any changes retrospectively to those already on a qualifying route. Now remember, these are recommendations only and do not change the law. So what BWF Solicitors and this program we're going to do is to continue to monitor development and keep you informed. But there's some positive movement for UK migrants because the House of Lords, Justice and Home Affairs Committee has made that recommendation that government should not extend the standard settlement route from 5 years to 10 years and should not apply any changes retrospectively to those already on a qualifying route. And I said, and I want to repeat, these are recommendations only and do not change the law. But whatever it is, we're going to update you when there's any new development. Thank you very much for that. Now let's pick up our nugget quickly, and then we will drop those two in front of Lawyer Charles Asma for some explanation and clarification as well. Principle 7 of the SRA Rules for Solicitors 2019 as amended state that under the Solicitors Regulation Authority's rules for solicitors, a solicitor is expected to represent a client in a manner that promotes the client's best interest. This means that the solicitor must assess the client's case wholly and advise the client as to the realistic prospect of success. Good afternoon, Lawyer Charles Asma. I think your mic may be muted.
Yeah, can you hear me? Good afternoon.
Good afternoon. So I take the first good afternoon and bring it back to you. Good afternoon, Lawyer Asma.
Good afternoon, viewers and listeners.
Well, thank you very much for your time, and we want to say Happy Father's Day to you as well. We didn't have the chance to say that to you on Sunday, and I will, on behalf of viewers, listeners, and the community, to say Happy Father's Day. Though belated, we wish you the very best. I mean, as as my friend will say, well, obviously we have had some updates. The first one was the recommendation that has been made on the settlement route. I remember a few weeks back, you took us through some of the changes that are going to take place in autumn this year. And we're talking about the routes to indefinite. And some have been changed from 5 years to 10 years. Some caveats were giving us to the threshold for people to get to that indefinite threshold. This seems to be a recommendation that may vary one of them. Am I right?
Right. So, I mean, as it is, this is not law.
Mhm.
This is advice.
Right,
But as you know, advice is only in name.
right,
And if government feels that, yes, you've said your bit, but this is the direction of the government, the advice can be put aside. And that is
right.
why it's a recommendation. They believe that if this is done, it will be better. However, it is up to the government to decide what is best for the country.
Right. So, does it mean that those who were, if these recommendations are carried through, those who would have started a journey that would get them to the point where they will get indefinite, and it has been varied, may enjoy that privilege they had prior to the law being introduced?
Yes, that means there will be no retrospective effect, it will be progressive. What it means is that all those who were anticipating before the or who were in before the time or the change would
Mhm.
be spared, and those who will be coming in after the change would face the change or the effect of the change.
Okay. Are we very hopeful?
For me, anything is possible.
Mm.
We are advisors, especially when we come online or when we speak to the public. So we cannot say that we should remain hopeful. What we can say is that we should remain watchful and see what this advice will turn out to be.
Well, we are, for viewers and the community, we are expecting the changes to take effect from autumn this year, which is September, October, thereabout. If there's anything you need to do, do that now. If any preparation you have to put in place, put that in place now. Because we have said several times on this program, a stitch in time saves nine. So, what it is that you have to do, please get them together. And if you have any queries, any further explanation you would want, speak to a qualified lawyer. And I recommend that you speak to BWF Solicitors, located on the fourth floor of the Anna House, 214 to 218, Tottenham High Road, Seven Sisters in North London. You will find them working Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. And when you call them, you will use this number 0208 493 7340. 0208 493 7340. And when you do, you know the feedback that Elizabeth gave us about a particular member of staff, we have everybody behaving the same way, working very professionally, very passionate about what they do, very concerned about your situation, so they will find the best solutions for you. And they go according to what our nugget actually said this week, where the solicitors, SRA rules for solicitors 2019, as amended. The Principle 7 goes on to say that under the Solicitors Regulations Authority rules for solicitors, they are expected to represent a client in a manner that promotes the client's best interest. This means they must assess the client's case wholly and advise them as to the realistic prospect of success. That's what you do, I guess, Lawyer Asma.
Yes, exactly. We are required by the ethos of our profession to make sure that if the case does not offer prospect, we do not create false hope for the client
Mhm.
and say that we'll go and try. We have to be clear in our mind that there is prospect for the client. Otherwise, we will not be acting in their best interest.
I, to the ordinary person, lawyers have answers to every question, don't you? So it could be, that's your question, there's nothing we can do about it. That's your question, we have 50% chance of succeeding. This is your question, there is every prospect that we will succeed with you. Those are answers the community I am proposing should expect from solicitors.
Exactly. That is why, for us as solicitors, we are supposed to assess the case wholly,
Mhm,
whole assessment, not partial assessment or assessment based on our own feelings or what we think we can try. There are instances where there will be lacuna or loophole within the rules, and we
mhm,
can tap into that loophole and fight for our client. But where the law or the rules are tight and there's no allowance anywhere, then why will you create expectation for the client that yes, it will work? For example, somebody has been banned for 10 years.
mhm,
Banned. The person did not challenge the ban, and 5 years into the ban, the person comes to you to say that I want to apply to enter the UK because I have an emergency trip. And you say, okay, don't worry. I'm a fighter. Let me just go and fight it for you. That is no realistic prospect of success because the rules are clear that if you are banned, you wait for 10 years, isn't it?
yeah.
So what are you going to tell the caseworker that, oh, my client, so how are you going to fight it? You only create false hope for the client. And what the SRA is saying that we are supposed to uphold the principles, one of which is principle number 7, which says that in acting, act in the best interest of the client. What it means is that if you are representing your client, as part of the advice and representation, and the key thing is the advice, make
Mhm.
sure that what you are telling the client is within the scope of the rules, i.e., the immigration rules. Assess the client's case wholly, understand the circumstances and the context, and be clear with the client that this case there's no hope, or this case there is some aspect of hope, and therefore let's go and try. Where we say let's go and try is what we say 50-50. So you tap into the client's 50-50. But where the success is 0 or 1%, then what are you going to say? That will not be in the client's best interest. It might be the solicitor's own interest and could be some other factors. But if it is client's best interest, then the client's best interest is that they don't have to waste time and money fighting a case that is dead on arrival.
Yes, so when you're approaching a solicitor, obviously have this expectation is I don't know, let's give it a try. Or this is your case when we assess it, there is a higher percentage of chance for you to succeed, and they will tell you. And as per the principle 7, they are supposed to give you that advice and act in your best interest. So I would recommend that you speak to BWF solicitors because they will definitely go by principle 7 and act in your best interest. Locate them on the fourth floor of the Anna House, 214 to 218, Tottenham High Road, Seven Sisters in North London. Call them 0208 493 7340 0208 493 7340. Now, having had this nugget, let me see if I can go into your brain and tease you a bit with this scenario. Definitely, I will put it to Lawyer Asma, but before then, try it. Now, it says that James instructed tried and tested solicitors on his immigration matter. He wanted his solicitor to present an application for him to the Home Office as a dependent of a skilled worker. During the consultation, he told the solicitor that he was a dependent of his wife who was pursuing a master's degree program. James added that his wife completed the course in 2026 and obtained a sponsorship to work for a care company as a senior carer. The solicitor advised him that his application will fail because he does not meet the requirements in affect the skilled worker to the immigration rules as the rules for dependents changed on the 11th of March 2024. He challenged the solicitor that as it is his application, the solicitor should go ahead to submit the application, but the solicitor declined to take up the case. Let me ask you, is the solicitor right? You can say yes because taking up the case means that the solicitor will not be able to act in James's best interest. No, the solicitor should be able to submit the application as long as it is James's wish, because he's come to you to require your services. Or you can sit on the fence and say none of the above. Tried and tested solicitors. James, the client. Do it because it's my case. No, I will not because he won't succeed. The laws have changed. No, lawyer, it's my case. Go ahead, do it. Tried and tested, are they right? Or James has the right to exercise his right? We will come back to this when we would have dealt with our main topic. But in the meantime, thank you very much, BWF Solicitors, for giving us the opportunity to come the way of the community to enhance their knowledge and also embolden them to be on the right hand side of the law. BWF Solicitors 0208 493 7340. And we are on social media on all the platforms like this. Thank you very much, BWF Solicitors, for the opportunity. This afternoon, we have a very interesting question, and BWF Solicitors is right on hand and on standby to help us answer that particular question. And we're asking, can I switch from skilled worker visa to EUSS pre-settled status? Can I switch? Yes? No? Maybe. Listen, don't worry. We have the right answer and the steps that you may follow if it is that you can switch in the discussion that we're going to have. And I am delighted to say that Lawyer Charles Asma from BWF Solicitors is right here with us, and he is ready to take us into that situation where we can have an answer. Skilled worker, why would you want to switch? And if you are switching, where are we switching to? One of the options probably is the EUSS pre-settled visa status. What about that? Layasma, good afternoon once again.
Good afternoon.
Yes. This question is a very interesting one. I mentioned in my introduction that recently we have had situations where people have had their visas or skilled worker visas curtailed. People have had some revoked, some licenses have been revoked, so it affects their status here and there. Then we also have had a situation where some people are giving 60 days to find something to do or return to their home country. The question is something to do within that period. Is it about switching? Is it about not doing anything? Is it about doing something? And if it is about doing something. That switch we're talking about today, is it possible? That's what we have come to help you answer for us.
Yes, so thank you very much, viewers and listeners. Once again, good afternoon. So today's conversation takes us into the realm of EU, where despite Brexit, people can still make application. If so, who can do that? And if the person is identified, how can the person make application that has realistic prospect of success?
Mhm.
So we know that after 2020, after 2020, we couldn't make EU applications, but the law allowed for individuals to still do so if they could meet the requirements.
Mm-hmm.
And here we are looking at direct family members. So we're looking at children, grandchildren, and parents and spouses. And for EU, there's no age limit for children. As long as you can prove that this is your parent or you are a child to this parent, you can. The law permits you. Just that if you are 21 years and above or over 21, you have to show that you need your parents to be able to survive. If you are under 21, you do not need your parents to be able to survive. So these are the two paradigms. Now, today we are looking at you came in as a skilled worker. You want to apply to remain in the UK with your family member who is from the European Union and living in the UK before Brexit. First things first, we are going to go into the rules, but I want us
Mm-hmm.
to look at some contextual viewpoints. The first viewpoint is that this family member that you are seeking to switch your visa to be able to remain with, was this person a family member that you've always had? Or in other words, is this person a family member that you've always had? How do we explain that? A skilled worker might have entered the UK in 2024. When the person was applying to come to the UK, the person was asked on the application form, do you have anybody in the UK? Or do you have any family member in the UK? Or do you have any friend in the UK?
Mm-hmm.
On all these three questions, to all these three questions, the person answered no. What does it mean? They have nobody in the UK, isn't it?
Yeah.
Now, in 2026, the person wants to apply to remain in the UK based on a EU family member who had been in the UK since 2020 or before 2020.
Yeah.
Question. Does it mean that when you were entering the UK in 2024 and they
You
asked you,
didn't
do you
know.
have a family member in the UK, you didn't know, or you forgot, or you didn't understand the question? These are not law, these are logic or common sense points.
Okay.
You were asked, do you know anybody in that office? You said no. So we take it that you are a stranger to that office.
Yeah.
1 week later, you come and say that, oh, I know Lawyer Charles. He's at that office. What will you make of that person?
The first impression would be the person is lying because probably he wants to say something to gain a favor.
So to speak. So the point we are making as part of the context is that the family member that the skilled worker is seeking to switch a visa to
Mhm.
should be legitimate. And that
Okay.
should reflect the historical facts that the Home Office has about you, the applicant, and your knowledge of that person that you claim is now in the UK.
Okay.
If the facts are not consistent, it will be difficult.
So if I say that, or when I was applying and I did not state that I knew anybody who was an EU person in the UK, but then I come to find out that I had a relation. Now I'm going to vary the answers I give them. Um, it's not possible at all, or I would have to prove that I didn't know and that I am aware of the person's existence now, and this person truly exists in the UK. Can I do that?
When you are making application, which we'll come to,
Mhm.
depending on the age of the person must show dependency.
Okay.
Dependency should be past and present, and of
Hmm.
course, future.
Okay.
It doesn't have to be whole. In other words, it doesn't have to be 100%, but it has to be something. So, if you are going to prove the historical dependency that your mother or the father or your grandparent was looking after you before you traveled to the UK, how could they be looking after you if you didn't know that they were already in the UK?
That's not possible.
You see? Then, because even though you said that, oh, but it's possible the person didn't know and they became aware when they entered the UK, fair point. But the person also have to prove that they were being looked after by this so-called family member prior to their arrival in the
In the
UK.
UK.
And upon arrival, they continue to depend on the person. So how will you prove that you didn't know that the person was in the UK, and at the same time that the person was looking after you because the person was living abroad and was sending you money? So that becomes a point for doubt on the balance of probabilities. Will the person be depending indeed on this family member, or it's a circumstantial explanation for a reason?
Okay.
Right. So these are the context. The
Okay.
third context, so the first context is the knowledge. The second context is prior dependency. The third context is this. When you are making application to enter the UK as a skilled worker,
Hmm.
your application for skilled work visa will require you to state your parents' details.
Okay.
So they will ask your parents' names, father and mother. More often than not, you would want to remember and state that yes, you have. If they are dead, even if they are dead, you still write them down.
Hmm.
So let's assume that this person has written them down, because you remember we are talking about skilled worker who has entered the UK and wants to switch. So it's not like the person is now about to make application from abroad. They have made the application, been granted the visa, and already in the UK. At the time you were making the entry clearance application on that form, one of the question is, what are the details of your parents? You said that my father is Charles Asma. His date of birth is 1/1/1909. You said everything. You mentioned the nationality, Ghanaian, and remains a Ghanaian. You said all that. You enter the UK. You are going to make application under your mother or father who is from the EU and living in the UK.
Hmm.
They are going to ask you the same question. What are you going to say?
It may be difficult because different people now,
Why will you have two parents, two mothers, biological?
biological, it can't be possible.
On the balance of probabilities, what would the caseworker think?
You are lying.
It doesn't follow logic, and therefore you may not be satisfying them.
Successful. Yeah.
Satisfying them. So they will say, we are not satisfied that you meet the definition under Annex 1, a family member
Okay.
of the Appendix EU to the immigration rules. And a family member is defined as a family member in ascending order or descending order. Ascending order means from top down to children.
Hmm.
Descending order means from children down. So if you are a child, either way is the same thing. So if you're applying as a child, then the descending order, you have your mother there, you have your grandparent there. So within, under Annex 1,
Hmm.
definition to the Appendix EU provisions of the immigration rules. So if you are not able, if you're able to define that, yes, I am a family member, you have to
Hmm.
show that you are a child. How do you then show that you are a child? If one, you didn't know that your mother was in the UK. Of course, in terms of the evidence, you prove birth certificate or DNA. It's a choice
Mm-hmm.
which one you want to use. But
Mm-hmm.
then the fact, there's what we call prima facie. On the fact, does that make sense?
Okay.
Then that is where the caseworker will be making such analysis or assessment to say that we don't believe that this makes sense. So
Mm.
these are the context:
Okay.
knowledge, dependency, and parental relationship in terms of showing the family tree. Now
Okay.
let's
So before you go on, please let me find out this. You talked about the vertical relationship where is either from the parents down. So what if we're looking at something going horizontal? We're looking at cousins, aunties, and all the other bits. Those do not fall into this, do they?
they don't exist anymore.
Okay.
Yeah.
Well, so viewers and listeners, take note of that. Those ones don't exist anymore. When we're talking relationship, and when it comes to the EUSS bit, it's father, mother, and down, not the sideways relationship. Yes, last my yeah, we can go on with that.
Right. So we are going to look at our friend who has entered the UK as a skilled worker
Okay.
and wants to switch to a family member under EU.
Mm-hmm.
We'll look at one that has worked and one that has not worked. We'll
Okay.
draw the line between the two and conclude on why did this work and why did this not work.
No work.
What we're going to do is to look at the law. We'll then
Okay.
look at the facts and we'll conclude on analysis. Whilst doing that, we'll be adding or creating context by way of logical reasoning, by way of analogy, and by way of examples, just to consolidate the clarification that we seek to explore or
Okay.
create.
Okay.
Right. Producer, please, if you are available, kindly assist us with what the caseworker will be looking at. So our case, well, our client is John. Okay, John. So
Okay.
all going forward, we'll be making reference to John. John came as a skilled worker dependent.
Mm-hmm.
John came as a skilled worker dependent. And when we finish with John, we'll go to another client who might have come on different basis. Right. So we are going to look at the rules. What does the rules say? Immigration rules appendix EU. Okay. And when was the last update? Please up. Bravo,
29th
go.
April 2026.
When?
29th April 2026.
29th April 2026. Please, let's go for it.
Okay. So Immigration Rules Appendix EU and other EA and SWIT citizens and family members. So we have the
So
Appendix EU and other ones. We have the
we
purpose.
don't need a purpose because we know that it's a EU application.
Okay.
Requirements and procedure, very important. So we
Right.
look at requirement EU2. What does EU2 say?
It says the applicant will be granted indefinite leave to enter where the application is made outside the UK, or indefinite leave to remain where the application is made within the UK, where a valid application has been made in accordance with paragraph EU 9. The applicant meets eligibility requirements for indefinite leave to enter or remain in accordance with paragraph EU 11 and EU 12, and the application is not to be refused on grounds of stability in accordance with paragraph EU 15
Okay,
or EU 16.
good. So let's set the context here.
Mhm.
Producer, if you can give me federal assistance, if you can zoom what I don't know what is out or in, but I want to see it to be legible. Thank you. So what's this? This is out or in?
This is in.
In. So zoom in. All right. So if you look at EU2, it says your application should be based on certain things. So you don't just make the application. Now, it says that a valid application has been made, and a valid application means that you are using the right form and you have enrolled your fingerprint for you to meet EU9 requirement. So EU9 means your application is valid. And there are instances where you have to show validity by explaining why you are late. Because all applications that are going under EU now, you must show why you are late, because the final deadline was in 2021, June and August. So if you are doing it in 2026, validities are three. One, you've used the right form. Two, you've enrolled your fingerprint. And three, you have given reasons why your application is late or you are making it now. If these are all ticked off, then the application is valid and EU9 is met.
Okay.
Two, the applicant meet the eligibility requirement under EU 11 or EU 12. It says that for indefinite leave to remain, EU 11. So usually we say EU 11, EU 12 sparingly, but EU 11 is for indefinite leave to remain applications. Then EU 14, so it says the eligibility requirement for indefinite leave to remain or indefinite leave to enter or remain in accordance with paragraph EU. So leave to enter or leave to remain, that is, if you are coming abroad from abroad, is leave to enter. And if you are applying from within the UK, is leave to remain. Within the UK, you meet EU 11. From abroad, EU 12. If you say EU 12 or EU 11, it means it's indefinite leave to remain. That is a settled status application. EU 11 or 12. Then we go on to say that the application is not to be refused on grounds of suitability in accordance with paragraph EU 15 or EU 16. I'll go to the other point where it says the applicant meets the eligibility requirements for indefinite leave to remain. They should have included and also for limited leave to remain. Because somebody can also be making application for limited leave to remain, pre-settled status.
Okay.
And so I can see that there's a lapse there. The drafters of this rule, they missed that point. They only focused on indefinite leave to remain. But somebody can also be making limited leave to remain from abroad, pre-settled, or from within the UK, pre-settled. But why did they only mention indefinite? They missed that point. But they are human beings. So we're also saying that it can also be eligibility requirement should be met for limited leave to remain, which is EU 14. Right. Now we go to the last point. And you see the beauty of this. If you are not dealing with a pocket lawyer, and you are dealing with somebody who understands the law, who has applied the law, and who knows the nitty-gritties of the law, the person can easily point out that, no, the rules are even wrong. And they can still use it to support the application of the client. Because if I'm making my client application and I only see indefinite leave to remain and there's no limited leave to remain, doesn't mean I can't make the application. I can make the application and still say the application is coming under EU2. Even though you mentioned indefinite leave to remain under EU2 explanations, there is also EU14 for pre-settled status, and my client's application falls under EU14. You see, you point it out to them.
Okay.
Right. Now, the application should not fall for refusal under character or suitability. And this is where somebody might have been banned in the past. Somebody might have been picked up on deception. Somebody have any suitability or character issues that might have come up from the past. This can be used against them because they will not meet the requirement under paragraph EU 11, EU 15, and EU 16. So these are the things we have to be mindful of.
Oh, okay.
Now, it says the requirements for indefinite. Please, let's go there.
So it talks about EU2A, which says the applicant will be granted indefinite leave to enter where the application is made outside the UK. I think lawyer has reiterated that a lot of times earlier, or indefinitely to remain where the application is made within the UK. as a joining member of a relevant sponsor where a valid application has been made in accordance with paragraph EU 9. The applicant meets the eligibility requirements for indefinite leave to enter or remain in accordance with paragraph EU 11A, and the application is not to be refused on grounds of suitability in accordance with paragraph EU 15 and EU 16.
Now, Brako, so we are going to have a revelation very soon.
Mhm.
Now, you see what they are saying now. Requirement, look at the heading. Requirement for indefinite leave to remain. And they are clear that we are talking about indefinite leave to remain, right?
Yeah.
And they mention EU 11. Have you seen paragraph 2, the subparagraph 2 under requirement for indefinite?
Yes, where
The
the applicant
applicant,
meets the eligibility requirements for indefinite leave to enter or remain in accordance with paragraphs EU 11A.
good. That's the bit. That means if it is indefinite, it's EU 11. What about if it is not indefinite? And that is the next paragraph, requirement for limited leave.
Is not to be refused on grounds of suitability in accordance with paragraph EU 15 and EU 16.
Yeah, so let's go to the next heading.
And said
Requirement,
requirements for
yeah.
limited leave to enter or remain other than as joining a family member of a relevant sponsor.
Now, Branko, could go to the second paragraph of this main paragraph.
So it says the applicant does not meet the eligibility requirements for indefinite leave to enter or remain in accordance with paragraph EU 11 or EU 12, but meets the eligibility requirements for limited leave to enter or remain in accordance with paragraph EU 14.
Remember, I told you that the original paragraph we were reading was only making reference to indefinite.
Mhm.
And because they made only reference to only indefinite, they only mentioned EU 11. But the paragraph was generic. And that should have been or EU 14, because there could also be application which is limited leave to remain. And that is where we are now. And that's why I said we are going to have a revelation where we are now told clearly that limited leave to remain applications under EU rules, we have EU 14. So when you mention EU 14 to the caseworker, a good caseworker will understand that that is a limited leave to remain application.
Okay.
Then, of course, the suitability applies across board. So we are looking at two sets of applications that can be made by this skilled worker,
Mhm.
switching to a family member of an EU, of a family member of an EU national, either for indefinite, which is EU 11, or EU 14 for limited leave to remain. There's something they mentioned. They said a joining family member of a relevant what? EU
Sponsor.
national or relevant sponsor. That sponsor is the EU national. So we
Right.
sometimes say relevant EU national. That relevant, what is the meaning of relevant? Relevant means important, isn't it?
Mhm.
What makes that person important is whether the person is indeed qualified to live in the UK under EU rules.
Okay.
After Brexit, they said that all EU nationals who want to remain should apply under EUSS, right?
Yeah.
So if you did yours, you have become a relevant sponsor. If you didn't do yours, you are not a relevant sponsor. You are just a visitor living in the UK.
Mhm.
So when you are making an application, you have to show that the family member that you want to remain with, who is the EU national, has him or herself obtained EUSS, either indefinite or limited. That's settled status or pre-settled.
Mhm.
If you are not able to prove that, then that person cannot sponsor you. They themselves are at risk, let alone to sponsor somebody.
Sponsor you.
So let's remember that. So we've now arrived at the third point. Apart from the eligibility EU 9, where you have to look at the right application, you have to look at enrolling your biometrics, you have to look at showing why you are late, the reasonable grounds for lateness. You also have to show that the person who is sponsoring you, him or herself, has first obtained EUSS certificate. That is indefinite leave to remain or pre-settled status. If they don't have it, they can't sponsor you. They haven't gotten it. How can they transfer to you? Does that make sense?
Yeah, it does.
So that's why when you are making application, they will ask you, do you have the EUSS reference number for the sponsor?
Okay.
If you don't have it, it means that sponsor is not a relevant
It's not a
sponsor.
relevant one, yeah.
But
Because
they themselves don't
they
have
may
it.
not qualify themselves.
Exactly. So what it means is that not every EU national or family member can be relevant enough to sponsor a skilled worker who wants to switch. So be watchful to know whether they themselves can help you or not. If they haven't helped themselves already, can they help you?
Hmm. They can't.
No, they can't. Thank you. So we are breaking it down, we are making it practical. I want all of us to understand before you do it, you know that you have realistic prospect of success. Let's now move to, please go down, requirement, we've covered that. Um, we've covered that. It's the same as the one above. So, okay. Now it says other provisions as to requirements and procedure. EU4. What does paragraph EU4 say? Please help us.
So it says where a person has been granted limited leave to enter or remain under this appendix, they must continue to meet the eligibility requirements for that leave which they met at the date of application, except for any which related to their dependency as a child, dependent parent, or dependent relative, or meet other eligibility requirements for limited leave to remain or enter in accordance with paragraph EU 14 where they have been granted limited leave to enter or remain under paragraph EU3, or in accordance with paragraph EU 14A, where they have been granted limited leave to enter or remain under paragraph EU3A.
Okay, all right. So, Bragoku, what this is all saying is that if you are not making application for indefinite, you just have to prove that you are either a child, a parent, or a dependent relative of a sort.
Mm.
And the skilled worker person who is going to switch will come under dependent parent or dependent relative or dependent child, right?
Mm-hmm.
Yeah. So that's the context. So this bit is just about relationship really. Let's
Okay.
move on to the next, please. Scroll down for us. So now we've covered the main ones. Valid application. What makes a valid application? That is UU9.
Okay. So just before I read, I just want to remind viewers that we're looking at where it is possible to switch from sponsor license to the EUSS uh, pre-settled status. And lawyer has guided us through who would be the relevant sponsor and what qualification criteria they need to meet. And then when you have really gone through that, what type of application do you have to put in? That's where we've gotten to, where we're going to read what the guidelines say about the valid application. And that takes us to EU9. So, lawyer, with your permission, I'll go on to read. And it says, a valid application has been made under this appendix, where A, it has been made using the required application process. B, the required proof of identity and nationality has been provided where the application is made within the UK. C, the required proof of entitlement to apply from outside the UK has been provided where the application is made outside the UK. And D, the required biometrics have been provided. E, it has been made by the required date, where the date of application is on or after the 9th of August 2023. And F, the applicant, if they rely on being a joining family member of a relevant sponsor, and where the date of application is on or after the 9th of August 2023, is not a specified enforcement case. That has been highlighted, so I know definitely when lawyer comes in, he will give us those explanations to those. You have the required days, required biometrics, required proof of entitlement, required proof of identity and nationality, and all coming in this process. Now, EU10 says, 1. An application made under this appendix will be rejected as invalid where it does not meet the requirements in paragraph EU9. And 2, it says, paragraph 34B of these rules does not apply to applications made under this appendix, where a further valid application is made under this appendix before a previous such application has been decided. The further application will be treated as application to vary the previous application, and only the latest application will be considered.
Right. So there are instances where somebody will say, I've made a mistake, and they are making another application
Right.
to override the first one. So if you make an EU application and you make another EU application, the latest one will take over the first one.
Yeah.
And the timing, the deadlines are very, very important. Now, we have looked at all the basics. The next thing we are going to be looking at will be the deadlines. Then we look at examples.
Okay.
So the deadline, producer, please check the last bit for us, the last resource. The last resource, producer. Yes, so down, 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 after you've arrived. After you've applied, no, okay, scroll down, scroll down. Um, scroll down for us. Who can? So after you have arrived, I think go to the last. There is the table down. Yeah, this one. No, that table.
Okay.
Yes. So the key deadlines when you have to make the application.
So you are applying as a family member of someone from the EU, Switzerland, Norway, Iceland, or Liechtenstein who's been living here by 31st December 2020 and has settled or pre-settled status, and you joined them in the UK on or after the 1st of April 2021, and you did not enter as the UK, you did not enter the UK as a visitor, and your deadline to apply will be 90 days from the first date you arrived in the UK after 31st December 2020, or when your permission to be in the UK expires, whichever is later.
All right. So let's take somebody who is a skilled worker.
Mhm.
The person entered the UK in 2024.
Yeah,
The person did not do anything to switch until 2026. How many days has elapsed already? It's more than 90 days, right?
yeah,
But we are told that if you join a family member and you want to make an application to switch, you have to do so within how many days?
90 days from the first date you arrived.
Yes. So if you arrived as a skilled worker, within 90 days, you have to take steps to switch.
Right.
If you decide not to switch and you are switching later, you have to give reason why you are late
Okay.
in making the application. And
But
that reason,
in the paragraph that talks about the deadline to apply, the second part says, or when your permission to be in the UK expires.
yes, it says, or when your permission to be in the UK expires. Yes, there's whichever is what? Later.
Later.
So somebody can say, okay, I'm going to choose that one because that is later. And this is somebody will say that a good lawyer will say, well, that is the loophole that I will explore to defend my client.
Mm-hmm.
Because the
Okay.
rules say 90 days.
Right.
And it
And
also
gives a
goes on to
caveat
say
after
that.
that.
Come again?
He gives a caveat. The law gives a
It
caveat.
gives a caveat or it gives flexibility. So we
Okay.
are tapping into that flexibility in defense of the client to make the application. That yes, they should have made the application in 90 days. However, there's also opportunity given within the rules to do it later before the visa expires and they chose
Mm-hmm.
the letter.
Right.
Right. So these are all there. That is why sometimes you make your application and they write you to say that can you give reasons why you didn't make the application within 90 days that you were in the UK.
Mm-hmm. But then
Then
I can put up the argument to say that per your guidelines, you say, or when permission to be in the UK expired, and I've chosen the letter.
Yes, you can put up that argument. But there are also instances where it's so obvious that the person would have to explain why they made the application late. And that is crucial that we mention. It's not always the case that you choose the latter to defend. You also have to
Okay.
give reason why you didn't put in the application in time. Right.
Okay. Right. Now, the second bit says that you are applying as a family member of someone from the EU, Switzerland, Norway, Iceland, or Liechtenstein who was living here by 31st December 2020 and has settled or pre settled status. And you joined them in the UK on or after 1st of April 2021. And you entered the UK as a visitor. The first one says you did not. Now, this one says you entered as a visitor. And
So
your
there are
deadline says,
Okay, sorry. So the first one is for those who did not enter as visitors. So those
yes.
who did not enter as visitors will be skilled workers.
Okay.
And there's somebody who might have come as a visitor, and after their visitor's visa has expired, they decide to switch. But here it says that don't wait for the visa to expire. Within 90 days, you have to. And this one, there's no caveat.
Okay. Yeah. Okay. Now,
Okay.
the third one goes on to say you're applying for your child who was born or adopted in the UK on or after the 1st of April 2021. And their deadline says 90 days from when your child was born or adopted.
Right. So this is where um, a skilled worker has entered the UK, gives birth, and the
Mhm.
child's grandmother or father is a relevant EU national in the UK, and they want the child's application to be made under the grandchild or the grandmother. You have to apply within 90 days that the child was born. If you are applying after 90 days the child was born, you have to give reasons why.
Okay. So then this grandson or grandchild or granddaughter would become somebody under the EUSS pre-settled situation.
Yes. So
Okay.
application will be made under EU 11, EU 14 for normally with children it could have been EU 11, but these days they give all of them EU 14, which is pre-settled status. So the application will be made, but the key thing is not what they are getting, but when the application should be made
Should be
for
made.
it to be valid. So as soon as the child is born, after registration, you go ahead to make the application, all within 3 months.
Within 90 days, 3 months. And I would want to say again, I've said and I've said earlier on, I think I've repeated and I want to do that again, that a stitch in time saves nine. So remember the deadlines that I've been giving within 90 days. Within 90 days. The only one that has a caveat is where they entered as non visitor or, yeah, so to speak. So that is where the skilled workers come in. But as much as possible, do that within 90 days. If you're going for the other part of the flexibility, you would have to provide some convincing reasons and evidence that you are not able to do that within 90 days. The last bit says you are the family member of an eligible person of Northern Ireland, but they could not move back to the UK without you or by 31st December 2020. You must be from outside the EU, Switzerland, Norway, Iceland, or Liechtenstein. And that has to be done 90 days from when you arrive in the UK. You
Yes.
are
I think
you're
so.
exempt from,
Sorry, this is for Northern Ireland, Northern Ireland.
yes.
So it's quite straightforward. We
Okay.
move down to the key people. What about somebody who doesn't need a visa to be in the UK? Can they apply under EU? Let's look at the law.
Now it says
Exempt.
that you are exempt from immigration control or you stopped being exempt from immigration control after the 30th of June 2021. And it says you are exempt from immigration control. You do not have to apply to the scheme. If you choose to do so, you can apply at any time. If you stop being exempt, you have 90 days to apply.
So if somebody is an exempt, those people don't need visas. Example, armed forces. Once
Okay.
you are enrolled in the armed forces, you become an exempt person. So
Mm-hmm.
if your grandmother or mother, grandfather, or even a mother or father is an EU national, or even your child is an EU national, and you want them to sponsor you, you cannot make the application because you are exempt. If you make the application, will it be valid? No,
No, because you're exempt.
because exempt, it can't work.
Yeah.
So if you want to do it, then you have to leave the armed forces. So you become exempt. You leave, then you cease to be exempt.
Mm-hmm.
Then you can go for the shortcut of applying as a family member.
Right. And
Yeah.
the last bit says you were living in the UK by 31st December 2020, and you got limited leave to enter or remain in the UK before the 30th of June 2021, and that leave expires after 30th of June 2021. And what they are saying is do it before the leave expires, which
Yeah.
would have expired by now.
Well, so if it is expired by now, then you have to give reasonable grounds for lateness.
Well, no, I would continue to ask the question. If I do not apply by the deadline, you're talking about giving reasons and all that. Want us to hold a thought on that, take a quick break, and when we come back, we delve deep into that and then pick up some questions.
But
It's the
all
community.
right.
Say again.
I was going to show you something before the producer lifted that resource. And that will be the basis for your next question when we return.
Yeah, definitely. I would want to leave that juicy part for us to come back to when we return from the break. It's the community, and the law is brought to you by BWF Solicitors. Our resource person this afternoon is lawyer Charles Asma. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Thank you for sticking around, and thank you for staying with us as the community on the law. We're looking at whether we can switch from skilled worker visas to the EUSS pre-settled status. Large Osasma from BWF Solicitors has been helping us, and we looked at the qualifying people or people who can sponsor you under the EUSS pre-settled. We looked at some dates. We have looked at some deadlines, and we are asking the very interesting question: where you were not able to apply by the deadline. In the meantime, if you have any question, you can put them in the comment section down below, either on Facebook and YouTube at BWF Solicitors and at BWTV UK. You can also send a text or WhatsApp to line 0739920848, or you can call us on the line 0208 493 7345. Lawyer Asma is still here with us. Now let's look at Lawyer. That juicy part I deferred to after the break. If you do not apply by the deadline, what does the law say?
Yeah, help us with what the law says.
Well, we have the resource on the screen, so with your permission, yes, I can read that. You can still apply if you're eligible and can show reasonable grounds for why you could not apply by the deadline or in time since the deadline passed. And then it continues to tell us who is eligible for the EU settlement scheme. Uh, yes, I continue to read your permission. You must meet one of the eligibility criteria for the scheme, which for most people is either you are from the EU, Switzerland, Norway, Ireland, Iceland, or Liechtenstein, and you started living in the UK by 31st December 2020.
So,
And the other bit, yeah.
Branko, you said so. You see that this is for EU nationals
Yeah.
themselves.
Okay.
So we are interested in family members because the skilled worker will be a family member. So who is eligible for that? So scroll down from this point, producer. You may and down. Okay, reasonable grounds for delay in applying. So the ones we had above would be family members. And the family members mainly would be they show the relationship, whether they are they are children or parents or grandparents or grandchildren, they are able to show that. But if the person is late, that is important here.
Hmm. So then let's look at that. And it says if you did not apply by the deadline for your circumstances, you may still be able to apply to the scheme. You can still apply if you are eligible and can show reasonable grounds for why you are applying now and not before the deadline or in time since the deadline passed. What you must give evidence of your reasonable grounds, which both explains the reason or reasons you could not apply, covers the whole period since the deadline passed, as well as why you could not apply by the deadline. And they may include if your parent or guardian or local authority um, did not apply for you when, can you scroll up for me? When you were a child or, and you have only been recently made aware of the need to apply. You have a serious medical condition which prevented you from applying. You lack the physical and mental capacity to do so. You have significant ongoing care or support needs. You've been in an abusive or controlling relationship or experienced domestic violence. You came to the UK on a work or study visa and became eligible to apply to the EU settlement scheme whilst you were here. Another compelling practical or compassionate reason. So when you apply, you need to provide evidence to support each reason you gave for the delay in applying, lawyer.
Yes. So your circumstance will determine the reason you have to provide.
Mhm.
If you're a child, you have to show that your parents couldn't have done it for you based on the circumstance. If you are, but we are talking about skilled workers.
Mhm.
These skilled workers who are switching can never be children, and therefore they will be adults. Why couldn't you do it within 90 days? Or why couldn't you do it before your visa expired if you chose the latter? What could be your reason?
Mhm.
Is it that you didn't know you have to apply? That will not be reasonable. Or your family member, there were issues within between you and your parent or you and your grandparent, and because of that, they use it as a way to punish you, and so they decided not to sponsor you until tempers were calmed and they agreed to go ahead. What's the reason? Or were they in prison, or you were in prison, so you couldn't apply? What others? Or you were so sick, or they were so unwell. Even if they were unwell, why couldn't you go ahead to instruct a lawyer to do, or do it yourself if you so wish, using their document? But again, they were not well, and so they couldn't have. But how long have they been unwell? And what's the evidence that they were not well? Evidence from where? GP or a medical doctor, consultant who was looking after them? How long were they unwell for? And does the evidence support the claim that they've been unwell for all this while?
Okay. So when the evidence is given, lawyer, it is at the discretion of the caseworker to say that they are convinced that your reasoning is tenable, and then they will grant you the ability to switch. So if they are not satisfied, they will not. So it does not become a tick box exercise.
Fantastic. So this is one area where the rules are qualitative in nature, where the
Mhm.
caseworker will say, all right, okay, makes sense. Or the caseworker will say, no, this doesn't really make sense. It defeats logic. So it's all about logical reasoning. And it follows logic. You are likely to convince the caseworker that they are satisfied that on a balance of probabilities, you couldn't have helped the situation other than to be late to apply.
Well, and I know you may have questions, you may have other issues you'd want to have Lawyer Charles Asma help you address. We have most of you with us online, Frank Mensah, Connie watching with us, Witty Blissful, Jay Kofi, Abna Baby Gift, More Africa Media. We have Emmanuel Young, Emmanuel Selassie King. We have Ocean, Grace Dance, Tilly Duma, Nespa for Eric Osu Ajay, Brenda Kwachi Sapon, and a lot more of you. You are all there. Chipa, Jima Ping Pong, and of course, Grace Dance, as I mentioned before. So keep your questions coming to Witty Blissful. You say it's an eye opener. Yes, and I believe that, as we have said, the Nugget clearly stated that you would have to see a solicitor, and the solicitor has a duty to act in your best interest as a client. Your best interest is what? We're giving you all the options. If the answer is no, it's no. They don't have to take your money to say, well, it's no, but I'm going to give it a try. If there is a good chance of it succeeding, they will look at the various options with you before they carry on with your case. And that's exactly what we're doing here. Can I switch? Lawyer is giving you the scenario, what the law says, and of course, managing your expectation as well. So keep them coming through. Your text number is 07399208468, or you can call 0208-493-7345, or leave them in comment section down below, either on Facebook or YouTube at BWF Solicitors and at BWTV UK. Now let's pick some of them and get lawyer to help us with that. But remember, I also gave you the scenario based on the nugget as to Bob and his encounter with his lawyer, insisting that the lawyer does something that the lawyer knows that is going to fail. The lawyer working with Principle 7 of the SRA Rules for Solicitors 2019 as amended said no, but Bob said, no, go ahead. It says who is right and who is wrong. Now let's pick up your questions and your comments now as we have lawyer Asma with us. Abdul Abid says that I'm married with a woman with 5 kids and she is on benefits, not working. She has indefinite leave to remain. I'm a skilled worker, but not working. Can I switch to a spousal visa, lawyer? I think you're muted, lawyer.
We're checking the woman's status. So the woman with 5 kids, she has indefinite leave. All right, okay. So she's a qualifying partner to this man.
Mhm.
And what does so the man is a skilled worker but not working. What it means is that he will not be able to prove the 29,000. But the wife, if the wife is working, can prove the 29,000. We are told that the wife is on benefit and not working. So the wife cannot prove the income from work. And so the this man will not be able to apply based on the spouse or the partner, but can apply based on the children who are his stepchildren, because he's married to this woman. So the children may be his stepchildren. And the rules say that if he cannot meet the requirement and the partner for 5-year route, they have to consider the exceptional circumstances based on the children under paragraph EX1A of Appendix FM to the immigration rules, because refusing his application will take away his opportunity to be there for the children. And so it will not be in the best interest of the children for him to leave the UK. And on that basis, he has to be granted. But the grant will not be the meritorious grant where he will be given under 5 years. Then he will be given under the section 10-year route as a step parent of a qualifying child. Again, we are not told what the children have. We are told that the children are 5, but we don't know their status. Since the mother has indefinite, we assume that the children have indefinite. If the children have indefinite, or the children are British citizens, or the children have lived in the UK for 5 years, or the children have EU nationality with 5 years pre-settled, or EU nationality with indefinite leave to remain settled status, then we'll say that the children are qualifying children under section 117D 1A of the Nationality, Immigration and Asylum Act of 2002. And so this man can apply on the basis of these qualifying children. He has to show that he's there for the children, and there's evidence to support the claim that he plays a key role in the lives of the children based on his marriage to the children's mother, and they are living together. And because they are living together, the application will also be made under paragraph GEN. We call it Gen 3.1, Gen 3.2 of Appendix FM to the immigration rules, where there is family unit involved.
Well, thank you very much, lawyer. Keep them coming through. Bring them. We will get lawyer to help us unravel that. Angela has a Ghanaian district court divorce certificate dated the 19th of May 2026. The certificate states that the ordinance marriage has been dissolved and that both parties are free to remarry. However, it also refers to the marriage having been customarily dissolved on the 23rd of May 2025. For UK skilled worker purposes, can this certificate be relied upon as a proof of divorce? And which date should be recorded as the divorce date, Law?
Well, divorce is divorce. I mean, whether it is customary, because if so, normally when people say customarily divorce, we are looking at the point where the family members agreed that the marriage is no longer continuing. So the drinks and the dowries and whatever there is, the customary symbols are severed by way of returning of the drinks.
Okay.
But returning the drinks is just symbolic. What qualifies as breakdown or the end of the marriage is the divorce certificate. So when they are issuing the divorce certificate, there is aspect where, depending on which country, but this person said Ghana. So with the Ghana certificates, we have divorce certificates based on ordinance marriages and divorce certificates based on customary marriages.
Mm-hmm.
Either way, the date should be one. Date of divorce should be one. Because if they are divorced, they are divorced. And whatever happened at home would have happened before the registration or the divorce proceedings will be filed and the proceedings taken through and concluded, which will end with the marriage divorce certificate. So this disparity in the date will create confusion for people. Because if somebody doesn't understand that the 23rd of May 2025 refers to the point where the families agreed that the marriage should end, and the 19th of May is when the proceedings ended and the divorce certificate was issued, there could be contention. So the person should possibly go back to ask, why do we have two dates? So that the doubt can be erased before the document gets to the caseworker.
So the divorce certificate that this person has would have been issued in court, I guess.
Yes.
So obviously, if he's going back, then he's going back to the court registry to find out why there are two dates.
Yes. So that's why. So that is why the question is posed: which of the dates are we relying on to prove divorce?
Okay.
You see where the contention lies.
Right.
Divorce is divorce. There will be processes leading to divorce,
Okay.
but such processes themselves do not amount to divorce. And so if the family members said that the drinks have been returned, that is the end of matter. But you want to confirm this with the registrar of marriages and divorces. So you go to the registrar, everything has been done at home. Families are aware that this is no longer going on. And so we want this registered. Then the divorce the registrar will, unless of course there is something, a letter to confirm that this date refers to the time the families agree that the relationship is over and is broken down irretrievably. But even within these proceedings, you realize that before the court will pronounce that the divorce is over, the parties will be given opportunities to mediate and to see if they could make amends.
Reconciliation. Yeah.
Yeah, reconcile. So the fact that the families agreed that this is over doesn't mean it's over. And that is why the date should be the final date.
So it's possible that the date from the court could be wrong because obviously it should have been after the family had dissolved.
Yes, but so whatever the person is showing suggests that the the date the family dissolved the marriage or said that it is over between our family members has also been mentioned.
Yeah.
When it comes to marriage certification, the date of the marriage is mentioned and the date of registration of the marriage is mentioned. Because in Ghana, under the Marriage Act, so the Marriages Act of 1884 to 1985, for all sorts of marriages in Ghana, Section 3 and other sections will say that once the marriage has taken place among the families, you can go ahead and register your marriage. And at that point, the registrar will want to know whether it has taken place indeed at home and the customary activities have been performed and the marriage has happened. So we'll have date of marriage. And that date of marriage could always be, or could normally be earlier than the date of registration of the marriage. So that we have two dates.
Okay.
But when it comes to divorce, we cannot say it has to follow the same principle because
Right.
the divorce will be a lengthy process. We call it divorce proceedings. It includes mediation, conversations, and the resolutions here and there. If all these do not work, then the registrar will say that we've gone through the proceedings, it wasn't contested, it was contested, and finally the judge has pronounced that the marriage that was contracted at a particular date is now over and divorce certificate is issued.
Okay.
So to say that it actually ended at home on this date, and for us we are rubber stamping it, makes it ridiculous within the rules.
Okay. Yes, keep them coming through comment section down below at BWF Solicitors, both Facebook and YouTube, and at BWTV, both Facebook and YouTube. I've indefinite leave to remain, about to apply for British citizenship, but I have 6 penalty points and a fine for driving without insurance as a learner. Will this affect my application? I have a British child, lawyer.
Well, so it doesn't really matter whether it's a child, you are applying based on your child or based on your spouse. The bottom line is that there is character issue, suitability, under part suitability to the immigration rules, previously part 9. Now, one of the character issues raised here is driving offense. It says I have 6 penalty points and a fine for driving without insurance as a learner. Will it affect? We want to know how long. So on the application for naturalization, the person will be asked, do you have one of the following? The last time we talked about it. Do you have one of the following? And one of such things will be the driving related offenses, penalties, and so on and so forth. So if there's penalty among the list, you have to say yes. Then you give yourself opportunity to explain the circumstance, when it happened, how it happened, and what is going on. Then you can water it down to say that, so that they will look at whether the threshold is above or below. Remember, we talked about above and below threshold. If it is above the threshold, then it is serious. It will affect the suitability point. It will affect the application. If the threshold is not met, in other words, if it's below, the caseworker will make a favorable discretion to say that yes, you have 6 points. Yes, you were fined. Yes, all that. But over the period, you haven't had that offense again, or you haven't committed that offense over the period of 6 months or 1 year or 3 years or what have you. So you have to explain in that box that in 2024, I was given 6 penalty points and a fine for driving without insurance. This is because at the time I was encountered by the police, I discovered that my license had actually expired unbeknown to me. It's a genuine oversight, maybe, but it doesn't mean that you can go scot-free. So you are punished. But the question is this a deliberate character matter? That is where discretion will come in. And therefore, on the balance of probabilities, this person can argue that the offense here falls below the threshold for suitability and should not affect grant of nationality.
It is always best for a layman to give their job for an artisan to do for them. When it comes to legal matters, I am going to say and repeat that you give your stuff to BWF Solicitors to handle for you, because they will definitely follow the SRA regulations and advise you, especially you, in your best interest. Now, I have this scenario where my friend Bob had this situation and approached, tried and test. In fact, James instructed, tried and tested solicitors on his immigration matter. He actually wanted to get them present an application for him to the Home Office as a dependent of a skilled worker. During consultation, he told the solicitor that he was a dependent of his wife, who was pursuing a master's degree program. He continued to say that his wife completed the course in 2026 and obtained a sponsorship to work for a care company as a senior carer. The solicitor from Tried and Tested Solicitors advised James that his application will fail because he does not meet the requirements of appending skilled worker to the immigration rules, as the rules for dependents changed on the 11th of March 2024. We're talking 2026. But James said, no, 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 no. It is his application. So the solicitor should go ahead to submit the application. But the solicitor said, no, I'm not going to take up this case because it's not in your best interest. The law to which you are applying has changed. Is the solicitor right? I have given you three options. Now, the first one is saying yes because the solicitor is right because taking up the case means that he, the solicitor, will not be able to act in James's best interest. We can also say no, the solicitor is not right because he should be able to submit the application as long as it is James's wish. Or I get you to sit on the fence and say none of the above. Nobody is right. James is not right, lawyer not right, whatever. Give me your answers. And whilst I wait for that, I'll take this short break, take you through my social media handles. And when I come back, I will take your answers. And then I will put it to lawyer to help us see who is right. Would it be the solicitor? I don't know. Fingers crossed. We'll be right back. Well. James and the solicitor from Tried and Tested Solicitors. Who is right? Is the solicitor right? Is it yes? Is it no? Is it none of the above? Mary Jessie says yes. No, sorry. Mary Jessie says number two, no, the solicitor should be able to submit the application as long as it is James's wish. Ignatius thinks it's one because taking up the case means that the solicitor will not be able to act in James's best interest. Stanley Mwasuka thinks it's number one. The solicitor is right. Francisca Ado thinks the solicitor is not right. Abraham Ajay, solicitor, is right. Russell Myong, I don't know, none of the above. Solicitor is not right. James's wish should be satisfied, so it's none. Ajawusu says yes, because taking up the case means that the solicitor will not be able to act in James's best interest. Imabo says number three. I don't know whether whoever is right. The next one says, Michael says, no, the solicitor should be able to submit the application as long as it's James's wish. Mercy thinks so as well. Once James says do it, do it. Daniel Armstrong Abuachi, once James says do it, do it. Francis Usu, none of the above. Francis, thank you. Michael Kakari says yes, because taking up the case means that the solicitor will not be able to act in James's best interest, and Anita agrees. Anita Jeboating agrees. Angela Champoma says none of the above. And then we take probably the last one. Witty Blissful says the solicitor is right. Now, I will take the nugget quickly again, and then I will throw both to lawyer and see what the answer would be. Under the Solicitors Regulation Authority rules for solicitors, a solicitor is expected to represent a client in a manner that promotes the client's best interest. This means the solicitor must assess the client's case wholly and advise the client as to the realistic prospects of success. Principle 7 of the SRA Rules for Solicitors 2019 as amended. Lawyer, Principle 7.
Principle 7. Principle 7 is client's best interest.
Right.
What is James' best interest? What James wants is to get a visa to be able to remain in the UK
Yeah.
so that he does not become an overstayer. That's what he wants.
Yeah.
Who's going to make it happen? The person who will promise to make it happen, isn't it?
Yeah.
Can the solicitor promise to make it happen? Now, we are looking into the facts. We are told that James is making a dependent application and that he is depending on the wife, right?
Mm-hmm.
The wife got skilled work visa after the rules had changed. The rules changed on the 11th of March 2024 to
Okay.
say that anybody who goes on skilled worker visa for the first time cannot add their dependent. If the person adds their dependent, the dependent will be refused.
Okay.
Who is the dependent?
James.
James. So the law says that James will be refused. That's the law. And the law from 11th of March 2024. James is torn between trying his luck or trying something else that may work for him. He believes that he doesn't have any option than to gamble it here. He's a risk taker. He doesn't want to take the risk alone. So he wants to share the risk with somebody. And the person here is the solicitor.
Mhm.
Can solicitor guarantee that James will get the visa so that he doesn't become an overstayer? The solicitor is not the one giving the visa. The solicitor must operate within the rules. So apart from the solicitor saying that James is a dependent of the wife, and the wife is a skilled worker, and the wife got the skilled worker that is prescribed, and that the rules in place from or in force from 11th of March 2024 are met. Can the solicitor guarantee that? No. The solicitor cannot change the skilled worker status because we are told that the wife became a skilled worker, senior carer. Senior carer is 6136. 6136, James cannot add to that application. And so, if James goes ahead, whether through the lawyer or through somebody else or himself, the visa will be refused. So, if the solicitor says that he's going to go ahead, then he's going to create false sense of hope and expectation for James. Because then James will be thinking that because the solicitor knows best and he chose to do it for me, that means it will work. Because he is the lawyer, he is the one holding the law. And if he says that it will work, it means he knows what he's talking about. But can the solicitor change the rule? No. The rules are not for solicitor to use anyhow. The rules are for the solicitor to follow the way they are. So the application will be refused if the solicitor goes ahead. If the solicitor goes ahead and the application is refused, will James be disappointed? Yes. Will James feel that the solicitor did not help him much? Yes. Why? Because the solicitor knows better. And if he couldn't, he should have told him that, no, as far as the rules are concerned, your application will not work. And so I will not take your money and just do anything for you. So no, no, no from me. The solicitor will do that. And if the solicitor does that, we say that the solicitor is doing the right thing for James, not the wrong thing. And therefore, the solicitor will be meeting principle number 7. He will be acting in the best interest of James within the rules. The answer is number 1.
So our solicitor from Tried and Tested Solicitors is right. And that's number 1. And under the Solicitor Regulation Authority rules for solicitors, they are expected to represent the client in a manner that promotes the client's best interest. This means they must assess the case wholly and advise them as to the realistic prospect of success based on Principle 7 of the SIA rules for solicitors 2019 as amended. And from that point, I am going to manage your expectation because we've come to the end of the program. But before we go, Lawyer Asma will give us a minute summary of what we discussed this afternoon.
Viewers and listeners, today we looked at skilled workers switching from skilled worker visa to EU visas. We understood that it is possible to switch, and therefore a skilled worker visa holder can switch to EUSS pre-settled status if the requirements are met. The first requirement is under EU9, paragraph EU9, which says that the application should be valid, i.e., the right form is filled, the person making the application has enrolled fingerprint or biometrics. The person, if they are applying outside the deadline or after the deadline, should have provided reasonable grounds for lateness and application submitted. We understood that in either way, the person making the application, the applicant, should meet the requirement under eligibility. The eligibility is either under EU 14 or EU 11. EU 11 is settled status. EU 14 is pre-settled. We are told that the skilled worker wants to switch to EUSS pre-settled status. So the application will come under EU 14, Appendix EU 14, paragraph 4, EU 14 of Appendix EU to the immigration rules. What does EU 14 say? EU 14 says that in applying for pre-settled, you must show that you meet the requirements. One of the requirements is that you would have lived in the UK for less than 5 years. If you have lived in the UK for less than 5 years, you can apply. And so the skilled worker visa holder who has lived in the UK for less than 5 years can transfer to EUSS visa if the other requirements are met. The other requirements are if they are applying as a child under 21 years, they have to show that this is their parent. So birth certificate or DNA to confirm relationship. If they are applying as spouse, they have to show that the marriage was there in 2020 before 2021 January. Most of the time, skilled workers will be applying in 2026 or 2025, and therefore it's not possible that the marriage would have been in 2020. And so this skilled worker can only apply under Appendix FN if he's going as a spouse. And so the person cannot apply under EU on the basis of marital relationship. So the next option will be as a parent. If this is your parent, you have to prove over 21 years of age. In addition to relationship, you have to show that this person who is your parent has been looking after you before you came to the UK, and since entering the UK, you have continued to depend on them for your essential living needs. The living needs are food, shelter, and clothing, physical or financial. We also have emotional needs that is met, counseling, guidance, and support. When there's something you have a shoulder to cry on or lean on, all that. So the emotional support, physical support, psychological support, and all the things that you need to be able to survive are provided for you through this person. Does it have to be 100%? No, it doesn't have to be 100%. And therefore, you have to show that it is sufficient. What is sufficient is based on the context, but you must prove it. So, how do you prove it? You came to the UK. Is it true that this person was your parent when you were coming to the UK? Did you indicate in the application? If no, how do you prove it? Was this person looking after you before coming to the UK? If no, how come they started looking after you after? If you came as a spouse or dependent and you came with your partner, how come you now depend on your parent if you were married, living an independent life with your spouse? Why will you now be saying that you depend on your parent for survival and so you want to apply under EU because your parent has EU status in the UK? All these are crucial. If you are not able to prove that, the application will be refused. Again, deadline. You have 90 days upon arrival or 90 days before the visa expired to put in the application. If you don't do that, then the application is likely not to succeed. During the discussion, we said that we'll give you two contexts. There's a case we did. The person applied before coming to the UK as a skilled worker, previously wanted to join the mother, who was an EU national with settled status, because the husband was EU national with settled status. Tried a couple of times, applications were refused. When the person was applying to enter the UK as a skilled worker partner, mentioned the parents' names. When entered the UK, immediately decided to apply to go on the mother's visa as a family member of an EU national. The application succeeded because this person was able to prove dependency, this person was able to prove the timing, and this person was able to prove that he could make a valid application. Another one, the application was refused because the person applied after the visa had expired, and therefore the timing was not right. Again, the person couldn't provide good reason for lateness. And again, the person was not able to show that this family member was looking after them whilst in Ghana before they came to the UK, and why they didn't immediately start to depend on this person, which is the family member, when they entered the UK. And therefore, on the balance of probabilities, they couldn't prove dependency. So you see instances where one will work and the other will fail, all on the face of the fact and within the rules. These are the things we have discussed. But in the round, we'll say that yes, you can. If you are a skilled worker visa holder, switch from that visa to EU pre-settled status visa if you meet the validity requirement, eligibility requirement, and all the requirements that come with this type of application within Appendix EU to the immigration rules. Thank you.
Thank you very much, Lawyer Charles Asma, for that very extensive discussion there that we have had today. And I believe that if you have any further questions, you won't hesitate to bring them over. You can leave them in the comment section below or send it to our text message number 07399 208468. 07399 208468. Then we'll put them to the lawyers for them to answer for you. Thank you very much, Lasma. Thank you very much, BWF Solicitors. And thank you very much, you out there, for staying and listening to us, sharing the page, and also asking your questions. You know what? I have another edition to give you same time next week. So I'm inviting you to come join us. In the meantime, let's say thank you again to my production team, Shilankra Padmododu, my studio manager, Professor Ade. My name is Oreku Frimpong. Have a good evening.